So, what do I think will change if we leave the European Union without a deal? Six things I think are going to change. Now let me emphasise, these are my predictions only. I have no inside knowledge. I know nobody who works bang in the centre of government, and I don't know anything about what will happen if we actually get a right-wing government that decides to bring down workers' rights. Remember, every political party has said they're not going to reduce workers' rights if we leave Europe. And doubtless they won't in the current parliament, but they are free to do so with future manifestos in future governments. So what do I think will change? I think there'll be two changes to TUPE. There won't be an abolition of TUPE. It's just too ingrained. I think two things will change. Number one, I think the rules on consultation will be relaxed. At the moment, you have to consult collectively if there is even just one person being TUPE transferred. I think that'll be brought into line with redundancy consultation, so you only have to do compulsory collective consultation if there are a minimum number of people, maybe 20, being TUPE transferred over. Does anyone know my favourite employment law joke, by the way? This is only employment lawyers are going to laugh at this, and you're only going to laugh out of a sense of sympathy for me. It's simply this: what do you call a woman with a mop and a bucket? An undertaking, bang on. That comes from a European Court of Justice case called Schmidt, which says that a single person, she was a cleaner, can be an undertaking. It's not quite as good as my other employment law joke. I only have two jokes. What claim did the clown bring when he was sacked from the circus? Funfair dismissal, exactly. Right, the second change I think will happen to TUPE is the law that says you cannot harmonise terms and conditions after a TUPE transfer will be abolished. That law is imposed on us by Europe from a case called Daddy's Dance Halls. I think we will be allowed to harmonise terms and conditions after a TUPE transfer. So those are the two changes to TUPE. Redundancy consultation, I think, will be relaxed, or at least the rules on compulsory redundancy consultation in collective redundancy situations. As you know, at the moment, in small redundancy situations and large ones, employers have to consult with individuals because failure to do so will make a dismissal unfair. So we have, under existing law, a requirement to consult with individuals. We also have, when more than 20 people are being made redundant, a requirement to consult with either unions or elected employee reps. Companies who recognise unions will consult with unions anyway. They don't need a law telling them to do that. So the law only compels union consultation in practice for employers who don't recognise unions. And I think that law will be relaxed so as to allow more redundancy situations to slip through the net and only force the very, very, very largest employers who don't recognise unions to engage in compulsory consultation with unions. Because, of course, those who recognise unions will do it anyway, and all employers have to consult with individuals anyway under unfair dismissal laws. Working time regulations. I think there'll be three changes. Change number one, the rule in TICO will be abolished. That's the rule that says that for peripatetic workers, people who don't have a fixed place of work, they travel around all day to different places, their travel time to their first place of work and from their last place of work home counts as working time under the working time regulations. That's a European case. I think that will be changed to come into line with the rest of UK commuting law, which is that commuting to and from work doesn't count as working time, doesn't count towards rest breaks, doesn't count towards the maximum 48-hour week. On which note, I also think the 48-hour week will be abolished. Everyone hates it. We're the only country that has an opt-out. That means that in England, you're allowed to request employees to sign something that says they opt out of the 48-hour week. It's completely ignored. Nobody follows it. There's never any prosecutions for breaching it. I think it'll go. And the third change, can anyone guess what I'm going to say for the third one, which is the most likely change to the working time regulations? Where do we need a big change on the working time regs? Holiday pay. Bang on. I think the government will press reset on all the cases we've had in the last 10 years on holiday pay, putting us back to the position where we no longer include commission, overtime allowances, bonuses, etc. in holiday pay.
Do you think that will include for maternity and long-term sick?
You mean about carrying over? Probably. But again, who knows? Once you start getting into the fine minutiae of proposed changes, it's impossible to say because the government hasn't even said, no political party said it's going to make any changes yet. So it's very difficult to predict the minutiae of the changes that they haven't said they'll make, if that makes sense. Yeah.
If we crash out of the EU, would the government need to set reset on holiday pay claims?
Yes. Because if we crash out of the EU, the default position will remain exactly as it is at the moment. So all European cases will continue to be binding and all European directives will continue to affect us unless and until the government changes the law. There's something in the withdrawal from the European Union Act, or whatever it's called, that means that the government can do it by statutory instrument. It doesn't need a primary act of legislation to do it, but the government can issue an SI to change any European law, but until they do, the European law remains binding. Most likely piece of legislation to be abolished. Everyone hates this. The agency worker regs, as you know, say that if you've been working for 12 weeks as a temp for a company, after 12 weeks, you're entitled to the same salary as the company's full-time staff. You're entitled to the same benefits, prospects for promotion, access to training, etc. Now, businesses hate this because they don't want to give training and promotion opportunities to temps they hire through agencies. Agencies hate it because when the salary goes up at week 13, it deflates their profit margin. Unions don't care. Unions don't care because temp workers tend not to be members of unions, and when they are, they're the more troublesome members of the unions because they only joined because they wanted to sue somebody in the first place. Number 5, discrimination. We're not going to see any protected characteristics being abolished. No government is going to put in its manifesto, we want to allow employers to discriminate on grounds of sexual orientation. It's just not going to happen. But I think we will see a cap on discrimination awards. Like we have for unfair dismissal, I think once we have the freedom to do so, if we crash out of Europe, there will be a 80,000 or whatever the unfair dismissal cap is, cap on discrimination payments also. Finally, family friendly. That's a tongue twister. Finally, family friendly. We're not going to see any changes there for the very simple reason that all the British family friendly laws are better than the European minimums. So, for example, in Europe, under European law, women on maternity leave are entitled to 14 weeks of paid maternity. In the UK, women are entitled to 39 weeks of paid maternity. Our laws are already stronger, therefore leaving Europe in a no-deal situation won't give us the freedom to change that we didn't previously had.